welcome to the farm. The Madras Bar Association has waged a decade-long war against the tribunalisation of justice in India. Its first big victory, albeit partial, was in the R Gandhi case. It did not succeed in striking down the creation of company law tribunals, but prompted the Supreme Court in laying down clear guidelines for the proper functioning of tribunals. Now, for the last decade, it has also been fighting against the National Tax Tribunal Act of 2005. Yet again, it has won. This week, the Supreme Court struck down the NTT Act, saying it is unconstitutional. The third and equally landmark struggle is against the National Company Law Tribunal and the National Company Law Appellate Tribunal as envisaged in the Companies Act 2013. That case is still work in progress. What will this week's victory against the National Tax Tribunal Act mean for tribunals across the country? Joining me to discuss that, Arvind Datar, the Senior Counsel who won the case for the Madras Bar Association, and former Solicitor General Mohan Parasaran, a man conversant with the point of view of governments. Now, gentlemen, before I come to you with questions, I do want to lay out for our viewers in brief what the Supreme Court had to say in this NTT decision. Here's what the Supreme Court said, that it is not per se a violation of the basic structure of the Constitution if Parliament was to vest the adjudicatory functions of a High Court with a tribunal, that the basic structure of the Constitution would be violated if the conventions and the salient characteristics of the court that is being sought to be replaced are not incorporated in the tribunal that will replace the court. That several provisions of the National Tax Tribunal are unconstitutional, and hence the Supreme Court has said the entire Act is unconstitutional and thus struck it down, and that neither company secretaries nor chartered accountants can appear before a National Tax Tribunal. Now, my first question goes to you, Mr. Datar. The first two conclusions that I've just read out are common to other Supreme Court decisions from the past. It's simply a reiteration that tribunals in themselves are not unconstitutional, but their features might render them so. And yet you chose to argue against the very creation of the National Tax Tribunal. Can you explain to us why? Because those arguments did not necessarily succeed.
Well, we didn't attempt to argue it again. The point is the Supreme Court has laid down certain guidelines on the creation of tribunals. Now, despite these guidelines being in place, Parliament drafts laws which are contrary to these guidelines. What the Supreme Court has been saying in the beginning is if you're going to take away the High Court's powers, then the tribunal which is going to replace the High Court in that jurisdiction, whether it's tax or environment, those tribunal members must have the same status, rank and competence as High Court judges. So when you start the National Tax Tribunal, you must make sure that it is as close to the High Court as possible. So this is just a formula laid down. And this has been reiterated in the context of the National Tax Tribunal because here was a case where they had gone one step ahead. You see, they have been creating company tribunals, environment tribunals and so on, which are basically on the original side as a first body of adjudication. But in the Income Tax Act, you already got a hierarchy of appeals. You've got the Commissioner appeals, you've got the Income Tax Appellate Tribunal, then the High Court and the Supreme Court. Here what they were doing was they were removing the High Court from all tax matters, whether direct, indirect tax matters, and substituting a National Tax Tribunal to decide substantial questions of law. And our fundamental objection was decisions on substantial questions of law is something which only the higher judiciary can do. This is part of what the American, English, Canadian courts have called core judicial power. And such core judicial power cannot be exercised by anybody else. If you do that, it will be a violation of the basic structure. So the the Supreme Court had to reiterate that principle in the context of what was being done in the National Tax Tribunal.
All right. Mr. Parasaran, there are flaws in the NTT Act and we'll get to them in just a bit. But before that, I just want to bring you in on the issue of the existence of tribunals in this country and the fact that the Supreme Court has blessed them as long as they have the features that make them equal to the courts that they are substituting or supplementing, right?
Yes. See, I would like to make a distinction.
Okay.
See, the power of judicial review under Article 226 can never be taken away. You can create any number of tribunals. You can even call it as a National Tax Tribunal or whatever it is. But even as against the judgment of a National Tax Tribunal, in my humble perception, the power of judicial review given to High Courts under Article 226 and under Article 32 can never be taken away. And looking from that point of view, what really happened was they created actually a National Tax Tribunal to actually virtually supersede the High Court to hear statutory appeals or hear appeals from high courts, and to that extent actually they created a body which was comprising not only of judges but also of outsiders, which was against the concept of the rule of law laid down by the Supreme Court in several judgments. And there I agree with Mr. Datar that this was against the recommendation of several bodies and judgments, and the time had to come that the court had to actually interfere, as this would actually be creating Babudam, in my view.
All right, gentlemen, I do want to get to the several sections of the NTT Act that the Supreme Court has found unconstitutional. I'll raise some of those provisions and get very quick reactions from both of you on what the impact of this striking down will be. The first one, for instance, the Supreme Court has said very clearly that chartered accountants and company secretaries cannot appear before the National Tax Tribunal. Mr. Datar, chartered accountants do appear before other tribunals in the country. What will this decision by the Supreme Court mean for that situation?
This particular paragraph has attracted a lot of criticism, and perhaps many chartered accountants will be unhappy with me and the association for this particular point. But you see, what our basic point was this. You are now replacing the high courts with the National Tax Tribunal. As you see in the judgment, we have been able to show that many cases of income tax are not really income tax cases. They deal with Hindu law, they deal with transfer of property, they deal with transfer of shares, company law, and so on and so forth. And we said that the arguments on substantial questions of law is something which is the domain or the expertise of advocates. You see, we have been trained as lawyers, we've been practicing for 2-3 decades, and we acquire some amount of expertise in arguments of cases in dealing with substantial questions of law. And we said that if it's going to be a high court which is going to be substituted by a National Tax Tribunal, then only advocates have to argue. This was a point taken by the Bombay Bar on this particular point, and certain other bar associations. They were very particular that if you're going to take away the High Court and create a substitute in the place of the High Court, then only lawyers must argue that case. And I think in that sense it's right. Like, for example, nobody can do tax audit but chartered accountants. So substantial questions of law is the expertise of lawyers. Chartered accountants can indeed argue before the Income Tax Appellate Tribunal, they can argue before the Central Excise Tribunal, they can argue before the Company Law Board, they can argue before other tribunals. There's no problem as long as it permits. But this was for the first time they created a super appellate tribunal deciding only questions of law. They were not going to deal with facts, not going to deal with anything but questions of law. And that's why the Supreme Court agreed with our submissions that if this is the kind of tribunal you're going to create, then only lawyers can argue the case. And mind you, there is virtually no other country in the world where substantial questions of law can be decided by anybody other than the courts of record, the higher courts, whether it's the US, UK. We demonstrated that to the court.
Do you think that this decision not to allow chartered accountants or company secretaries to appear before a National Tax Tribunal will impact their ability to appear before any other tribunals in the country currently?
No, if an ICS could preside over as Chief Justice of India, the Indian Supreme Court, why not a competent chartered accountant who also has a legal qualification? Most of the chartered accountants also have a legal qualification.
Yes, sir, but the Supreme Court has said what it said.
They normally interact.
Sir, so the Supreme Court has said what it said. So I'm just curious to know whether this will impact the ability of chartered accountants to appear before other tribunals, as is the case in the country right now.
This would naturally, of course, this will definitely actually affect the ability to appear before tribunals which have the duty to decide substantial questions of law, not necessarily the Income Tax Appellate Tribunal or the CISTAT or the Company Law Board as the practice now goes, no? Only special tribunals.
Which ones would those be, sir? I'm trying to understand the impact of this decision. Mr. Parasaran, which tribunals would those be?
The tribunals which are going to be created in future, like the National Company Law Board, etc.
Okay. Mr. Datar, you want a 20-second rebuttal on that point?
I want to just send 2 points there. I want all the chartered accountants and company secretaries to rest assured that their right to practice before all other tribunals is not affected. For example, every act says who can appear before that tribunal. So wherever the Income Tax Act or the Central Excise Act says that a chartered accountant can appear, their right of practice will not be affected.
Okay.
The impact of this decision is this. If tomorrow you create a tribunal which has to decide substantial questions of law in, say, field X or field Y, then to that extent, in that particular tribunal, non-lawyers cannot appear. That's the only impact.
two other provisions that the Supreme Court has found unconstitutional.
Yeah,
These are provisions of the NTT Act, that the government has the power to determine the constitution and the geographical jurisdiction of an entity bench and transfer members. This, the Supreme Court says, impinges on the independence of the National Tax Tribunal and is also against the separation of powers principle, and that accountant or technical members cannot decide on constitutional matters or substantial matters of law for which the NTT is being constituted. On the second point, I want to come to you, Mr. Datar. The fact that the Supreme Court has said that accountant or technical members in a national tax tribunal is unconstitutional. Now, we do have technical members in most other tribunals across the country. Will this decision impact those setups?
Your answer is yes. See, once again, this is a hypothetical question. Now, the formula is very simple. What is this tribunal designed to do? If it is designed to do substantial questions of law, then all these factors come into place. You can't have a technical member sitting on the tribunal. Now, one other point which you must note, which is very important, is that the National Tax Tribunal is not an ordinary tribunal.
Right.
It is a tribunal created under Article 323B of the Constitution of India. It's a constitutional tribunal as opposed to the Company Law Tribunal. Now, such a tribunal can decide the validity of various enactments except that law. It's a very peculiar provision. A member of the National Tax Tribunal cannot decide on the validity of the NTT Act itself. He can't decide the validity of the Act under which the tribunal is created. But such a member can decide the validity of the Income Tax Act, the Finance Act, so he can decide questions on validity of various other provisions. So here is a situation where you would have technical members from the tribunal who would become in the position of High Court judges, and they would then decide the validity under whether a particular provision is ultra vires entry 82 of the Constitution, under ultra vires Article 246 of the Constitution, which requires a huge constitutional background. And that was also one factor which weighed with the Supreme Court, saying that, look, if you're going to keep a tribunal having all the extensive powers of a High Court, then maybe it was a time to press the pause button and find out whether technical members can also decide this particular question.
All right, but Mr. Datar, I think the more important outcome of this decision will be what impact this will have on the presence of technical members, on other tribunals. And I understand you're drawing a distinction between what the NTT is and other tribunals in the country are. But I still want to understand whether the other tribunals will be impacted in any way by this decision.
No, they will not. So, but they will not at all. We have to make a distinction between tribunals and regulatory bodies. I think what do you mean is, I think Telecom Regulatory Authority of India or the SAT, SEBI and SAT, they also have lots of technical members.
Right, sir.
But they are not actually going into virus, etc. And they are not entrusted with the powers of a High Court. And where actually, as Mr. Datar says, if a body is created under the Constitution and is entrusted with constitutional powers of a court or a High Court, then you can't actually entrust powers on technical members who are not legally qualified to decide constitutional issues and virus of a statute, because they don't have that sort of expertise.
Exactly.
And the Constitution never actually vested such a power with those powers, and the Privy Council calls them as laymen, no?
Right. No, so Mr. Parasaran, I get the rationale for why the Supreme Court has decided this. I was just trying to understand, for instance, like you said, the Securities Appellate Tribunal or other tribunals that do have technical members on board, will that allow, will that persist, or because of this decision, will that have to change? And I think both of you are telling me that...
They are regulatory bodies.
So, okay, so they will not be impacted by this decision.
Bodies.
They will not be impacted by this decision of the Supreme Court. And I think Mr. Datar seems to agree with that as well.
No, I wanted to mention that, look, this judgment is not created some kind of a fear psychosis. Nothing is going to happen to any of the tribunals. All will function normally. Only you can't entrust substantial questions of law outside the outside the Superior Court. That's all. There's nothing else going to happen to any other tribunal.
Are you sure about that, sir? Because the other provision which the Supreme Court struck down as unconstitutional says that there was a dominance of government representatives on the NTT selection committee, and that the presence of government secretaries made the committee unconstitutional. The manner of appointment of NTT members should be the same as appointment of judges of high courts. Now, if the same measure is to be applied to other tribunals in the country, they too would fall short of having in place the same appointment process as the appointment of judges in high court. So again, this is the fourth provision that I want to bring to both of you and try and understand whether this striking down will impact tribunals anywhere else in the country. Mr. Datar?
Once again, I'll tell you, as far as ordinary tribunals are concerned, I don't mean ordinary in a pejorative sense. I mean ordinary means non-constitutional tribunals. As far as these tribunals are concerned, in the National Company Law Tribunal, or what's commonly called the R Gandhi case, they have said that the selection committee should consist of 2 judges. There's one nominee of the Chief Justice and one more judge, 2 secretaries. And in the event of a tie, there should be a casting vote with the Chief Justice. In other words, they say that if you're going to replace the High Court by the National Company Tribunal, then the views of the judiciary must prevail. Because in the NCLT Act, there were 2 judges and 3 secretaries. That was the problem. The same thing was the problem with the NTT Act. So now they have made it very clear that for selection of the tribunals, the views of the judiciary should prevail, because these tribunals are going to function, are going to use the, discharge the functions of high courts. As far as the NTT provision is concerned, that it should be in the same selection as a high court judge, this will primarily be confined to constitutional tribunals under Article 323B. For NCLT and so on, the formula laid down in the R Gandhi case will continue to apply.
Mr. Datar, can you tell me which are the other constitutional tribunals in the country?
Well, you have the Central Administrative Tribunal, you have the State Administrative Tribunals under Article 323B.
Okay, so those are the ones. Those are the ones who will have to toe the line laid down by this decision.
Yeah,
absolutely.
Okay. I'm glad you brought up the National Company Law Tribunal, Mr. Datar, because I want to put this question to Mr. Parasaran, sir. You were representing the government when this Companies Act 2013 was enacted, so to speak. Now, interestingly, there are flaws in that act as well, which the Madras Bar Association is litigating against. And I'm just curious to know, several of those flaws are common to the flaws that have, been discovered in the NTT, even though the NCLT and the NCLT may not be constitutional tribunals. Do you think the NCLT and the NCLT, Mr. Parasaran, are now doomed and that they are unlikely to see the light of day?
No, in my own perception, NCLT stands on a different footing. See, it's not a constitutional tribunal. Therefore, I think there, the principles laid down on Gandhi's case will be more applicable than in the present ruling. Therefore, I won't say it is doomed. Still, there is scope for argument. That's why that matter was not clubbed with this.
Mr. Datar, what is the status on the Company Law Tribunal case that you're fighting? Because that will be the 3rd important tribunal case that you will be representing for the Madras Bar Association.
The status of the case is it is now posted on the 14th of October for hearing. And the government has moved an application to try and complete the selection process, which we are objecting to. In fact, the National Company Law Tribunal judgment came in May 2010, 4 years ago. And there was nothing to stop the government from straightaway starting the tribunal and what you call taking away the powers of the High Court. But the whole difficulty was, that's our basic grouse against the whole system, that you are not creating tribunals as a part of a justice delivery system. You are creating tribunals with a completely oblique, malafide objective. You want to make sure that a group of retired officers will get post-retirement benefits. Now, the R Gandhi case said you can appoint secretaries, additional secretaries as technical members. You can appoint chartered accountants. You can appoint company secretaries. You can appoint district judges. You can appoint all these people as technical members. But they did not take a single step in that direction. Unfortunately, and if I may say so shockingly, they put in a provision which is directly in the teeth of what the Supreme Court said, and we had no choice but to challenge it again. Similarly, selection committee, once again they say there will be 3 secretaries and 2 judges. You're just inviting another objection from the Madras Bar Association, and we had no choice but to challenge it and come. And the other very important point which has to be dealt with is, from Chandra Kumar's case in 1997, for almost 20 years now, the Supreme Court has said that, look, if you want tribunals to function as independent quasi-judicial bodies, put them under the Ministry of Law as completely independent, and then start an independent nodal agency where there is uniformity of tribunal service and they are completely free from executive interference. You'll be surprised that the government has informed the Supreme Court that tribunals will not be put under an independent ministry because they are meant to serve the needs of individual ministries. That was what's Warren put on affidavit in the Supreme Court. So, apart from this particular entity or NCLT, there's a larger issue of where the tribunals are going to go, what is their role in the justice delivery system?
Mr. Parasaran, explain this to me. Yes. We've had the R Gandhi case that has laid down several guidelines for how tribunals should function. We've had the Chandrakumar case that dates back even further in history, which has laid down what the role of tribunals should be, how there should be a nodal independent ministry that manages them. Yet government after government seems to want to flout all of these Supreme Court guidelines, and they keep designing tribunals that are in violation of what the Supreme Court has laid down. Why is that, sir?
See, that's why I said this sort of a bobo down should go. See, recently you saw in the newspapers that there's a move to make the National Green Tribunal as part of the Ministry of Environment and Forests. They want to clip the parts of the NGT. And that's why I say I distinctly recall that I advised that you will have to tweak the provisions with regard to the National Company Law Tribunal. And I don't know where my advice went. And I think this government wakes up and does the necessary amendments, no? Otherwise, I think this will also go the same way.
Mr. Datar, the final word to you, since you've been fighting this battle not for a decade but almost 2 now. What do you think the future of tribunals in this country is?
Well, I know the Supreme Court asked us the question is why is the Bar Association, Madras Bar Association against tribunals? And we have repeatedly mentioned this, that we are not against tribunals. In fact, we want the tribunals to function because they are an essential part of the justice delivery system. Mind you, many cases are such that which the high courts cannot do effectively, like the Income Tax Appellate Tribunal. There is no substitute for the wonderful job they're doing. There's the Excise Tribunal, there's SEBI Appellate Tribunal. These are all specialized bodies which must exist. Now, what's the way ahead? There is a wonderful report by Lord Legate, and there's what is famously called the Legate Committee report, which contains several chapters on how tribunals can function independently. You've got the UK Tribunals Act of 2002, which has laid down very clearly how you can maintain autonomy of tribunals, independence of tribunals, and they can function virtually as independently as courts. Once the government makes up its mind that yes, tribunals are an essential part of the justice delivery system, point number 1. Point number 2, they should be completely autonomous. They should not be part of individual ministries. As a first step, everything must go to the law ministry. They should not look to their parent ministry for transport, health, and so on and so forth. They should be completely independent. And secondly, I feel that we must eventually make a step where tribunals are not post-retirement placements for bureaucrats and other judges. We should have tribunal service like the district judges. A young lawyer should be selected to go as a tribunal member, and a certain portion of the higher judiciary must be reserved for promotion of these members into the judiciary. So those are the 3 things which should be done in the long run. But as a first step, which can be easily done, is to make all tribunals under the law ministry and have uniform conditions of service, of recruitment, and so on.
All right, Mr. Datar, I do hope the government is listening to both you and Mr. Parasaran. We'll be also watching closely to see the outcome of your litigation against the National Company Law Tribunal and its Appellate Tribunal. Thank you to both of you for joining us on this edition of The Firm. And thanks to you for watching. We'll see you next week.